Welcome back to Good Law, Bad Law. More than 140 years ago, Congress passed a law that targeted the Ku Klux Klan and its acts of racial violence throughout the South and other parts of the country as well. Now, a group of lawyers based out of Virginia and New York are using that law to target the white nationalists, white supremacists, and neo-Nazis and their organizations who were behind the violence in Charlottesville, Virginia 2 years ago. They've brought a lawsuit. The court has endorsed its proceeding. They're taking depositions, and a lot of people on the far right are not real happy with this. It's a fascinating story. We revisit what happened in Charlottesville, what the lawyers have learned about the planning, the meticulous attention to detail behind that planning, and what the prospects are for bringing this case to court and justice for those who were victims of that violence in Charlottesville 2 years ago. Stay tuned. On today's episode of Good Law, Bad Law, we're talking about hate crimes again, a subject that is very much front and center in our politics and our political conversation, especially as the election season starts to get into somewhat of a higher gear. We're again talking about the very dramatic, important, and profound events that happened in Charlottesville, Virginia 2 years ago, August. And my guest today, Michael Bloch, a lawyer in Virginia, is one of the members of the legal team that is handling a case on behalf of victims of the Charlottesville protests, those who experienced violence, both physical and psychological violence. And I want to welcome Michael to the episode to talk about this extremely important issue today. Michael, thanks so much for being on Good Law, Bad Law.
Thank you, Aaron. Thanks for shedding some light on this issue.
Yeah, and I'm really looking forward to this again because as I find so often on our program, we take on issues that often people know something about. There's a familiarity generally with the topic, but there's so much about Charlottesville and what happened that I think hasn't gotten adequate coverage. And what's particularly striking and I think important about the conversation we're going to have today is how the law is being used in ways that I think are so important and that people need to understand better. And that's what I'm hoping we'll be able to really get into as we talk through what happened and what the victims of the Charlottesville violence are doing about it, with the assistance of you and the other members of your legal team handling this case, pending now in the Western District of Virginia, the federal court in the western part of the state of Virginia. So let's get into it. And first, if you would, Michael, give us a little background on yourself, on your firm, what you do, and how it is that you came to be involved in this case.
Yeah, thanks. So I graduated from law school in 2005. I clerked. I went to a bigger firm in D.C., and then I spent about 7.5 years as a public defender in the Bronx until last December. I had heard about Robbie Kaplan, who was somewhat of a hero of mine at that point, and the work that she was doing on the Charlottesville litigation. And I thought the firm seemed like it was doing excellent work, and I thought that the case was particularly important. And so I met Robbie and the firm last December. They told me that they were interested in folks helping out on the Charlottesville litigation. And so I joined. The firm itself does a mix of public interest litigation, commercial litigation, and white collar litigation. Mm-hmm. There are about 20 some lawyers in New York City. And one of our biggest public interest cases is the Charlottesville litigation.
And I know what public interest litigation means, but explain that a little bit for our listeners. What does that mean generally? What does it mean in the context of the kinds of work that your firm is doing?
Yeah, well, it's really an effort to use the law to address issues that arise in the public. So we very much at Kaplan Hecker we're sort of very attuned to what's going on in the world around us, and in this case in particular, I know that that Robbie saw the obviously the events in Charlottesville, as well as particularly, I think one real catalyst was the speech that happened by our president afterwards, which was upsetting to a lot of people, and so Robbie decided that something needed to be done about it, and so she found a tool to do it. In this case, it was the Ku Klux Klan Act of 1871, which allows private parties to sue for to the extent they are victims of a conspiracy of racially motivated violence. And so she brought suit in Charlottesville, and I think it's sort of the best example of a way that you can use the law to redress issues that and injustices that arise.
Well, and this law hasn't been used that much, though we've had racially motivated violence for a lot of years since the Civil War in our country. That in itself, I think, makes the case that you're handling pretty extraordinary and significant for reasons that go even beyond what happened in Charlottesville 2 years ago, I think. And I want to get into some of the broader implications here. But as to understand why this law relates here and is a tool that can be used to address what happened in Charlottesville, let's get a little bit of the background again on Charlottesville. I think it's something people have heard mentioned often, and some of us remember very well the images that we saw on TV and on the news. But and there are a lot of facts to cover, and we won't have time to go into all of the details. But give us what you think, Michael, are the sort of the most pertinent background details about what happened that ultimately give rise to your filing this lawsuit.
Yeah, so in August of 2017, a group of white supremacists descended upon the city of Charlottesville and particularly the University of Virginia campus, and really kind of unleashed a weekend of terror. I think the sort of most prominent incident was obviously the car attack where James Fields drove into a crowd of counter-protesters, but it really was an entire weekend of terror, frankly.
Mm-hmm.
Starting with Friday night, which was August 11th, when about 500 some Nazis and neo-Nazis and white supremacists, white nationalists, marched on the University of Virginia campus with tiki torches, chanting things like "Jews will not replace us" and "blood and soil," which is another Nazi catchphrase. And they marched through campus. They ultimately surrounded a group of students who were peacefully counter-protesting at the Thomas Jefferson statue, and ultimately ended up assaulting those counter-protesters by physical assaults. They threw torches, they punched, they kicked, etc. And that was Friday night. That event was regarded by the white supremacists as a great success, as a great sort of kickoff to the weekend, which led into Saturday, which I think is the day that is sort of most prominently discussed about when people refer to Charlottesville, and that's when there were the marching in the streets that also kind of erupted into violence by white supremacists against counter-protesters, and ultimately with James Fields driving his car through the crowd. I think what people may not necessarily know, which really is kind of the focal point of our suit, is that these events were very meticulously and carefully planned in the weeks and months leading up to Charlottesville by the white supremacists, and that this wasn't the violence that erupted was by no means any accident. It was kind of one of the goals and features of what the white supremacists were hoping for, and so they very clearly and carefully conspired to commit racially motivated violence throughout the weekend.
And, I think there's also been a lot of confusion, and I want to get into the planning of these protests, because I think from the materials I've read about the case, that seems very important to the proofs that are going to be required here in showing that this was a conspiracy, that this wasn't just random people coming together in protest, and that the planning involved plans for violence, so that this isn't one of those cases that we've seen at points throughout our country's history where even those who are voicing hateful speech or disgusting speech that we might all, or most of us hopefully would feel was really bad speech, nonetheless is speech protected under the First Amendment, but that rather this was meticulously planned, as you say, to foment violence and not just speech. So I want to get into the planning of that, because I think, again, from what I've seen, that's pretty important to the case that you're bringing. But there's been some, I think, confusion and maybe distortion, in part by our own president on this, that this was just a peaceful protest with, as he said, as President Trump said, at least at some point in time, with sort of reasonable and good people on both sides, the ones bringing the protest and those who were engaging in counter protesting. How do we know that, or how do you know from what you've learned about what happened, that that's not what this was? That although there was some early efforts to protest the whole issue of taking down of monuments to Confederate leaders during the Civil War, the statue of Robert E. Lee in particular was a focal point in Charlottesville. How do we know that this wasn't a case of, even if you might say so, reasonable protests about that issue, the issue of Confederate statues, but rather an organized campaign by some really bad people, white supremacists, neo-Nazis, people really focused on racially motivated violence and not just kind of despicable opinions about things? How do we know that?
Right. We know, and I think hopefully the world will know once this goes to trial, from the evidence that we've been able to gather thus far of extensive communications that they had on social media platforms, primarily the primary one being a gaming platform called Discord. But the Discord in particular had a specific server called the Charlottesville 2.0 server, where this event was carefully, thoroughly, meticulously planned, and it is abundantly clear that what they wanted was not, primarily was not just a peaceful protest by any means, but what they wanted was to commit violence, and it's fairly specific. There are careful plans about the uniforms to wear, about weapons to bring, about particularly how to bring items that can appear to be, free speech implements, but in fact can be used as weapons. There are videos about how to fight with shields. There's discussion about running over counter protesters. There's plans to have attorneys in place. There are plans to have medics in place. And the things that they were planning, the uniforms, the weapons, the sort of methods of formation and fighting, is exactly what eventuated that weekend. And then after the fact, it was celebrated. It was, and including the specifics. The death of Heather Heyer was celebrated. The weekend was considered to be a great success. So I think the evidence of racially motivated violence is substantial, and I think it is important to point out that our case does not target speech. It's absolutely the case that if what had actually happened that weekend was, peaceful protesting, a peaceful sort of, speaking, and of even hateful, despicable, odious messages, there wouldn't be this case. So
so again, this is, probably one of the most famous cases that stands in contrast to what happened in Charlottesville was a planned protest by neo-Nazis. This was many decades ago in Skokie, Illinois. Nazis or neo-Nazis in Nazi uniforms protesting in a heavily Jewish neighborhood in Illinois, but marching, not planning acts of violence. And that case, and I think the ACLU took some hits for this in representing those protesters and those marchers and their right to march and to even say things that are hateful or despicable and odious, as you say. That really does stand in very sharp contrast to what happened in Charlottesville.
Absolutely.
And this is not an opinion. This is something we can say objectively based on evidence that is on these servers, that is on these platforms, the planning and the speed, the words that they used to describe what they were going to do, and in fact what they did do before, during, and after. It's there. The evidence appears quite overwhelming and there to be seen.
Right, and I would just add that the focal point of our suit is that there is nothing that we are focused on that in any way we believe is protected speech. If conspiring to commit a crime requires speech, planning, etc., that when what you are doing is conspiring to, is sort of leading up to a criminal conspiracy, the speaking that goes along with that is not protected. Secondly, I would say that, and I think to some degree the defendants in our case, their sort of focus on the First Amendment, I think, is in some sense a red herring. If you, for example, were to beat somebody with a picket sign, it's not protected by the First Amendment just because the tool that you used was a picket sign. We are really focused on the violence and nothing that in any way we believe is protected by the First Amendment.
Well, so and this, what makes Charlottesville so extraordinary again is that it's not, if you're successful in proving your case, this isn't just a case of conspiracy to commit a crime. It's not merely conspiracy to commit an act of violent crime, because two people can get together and say we're going to beat somebody up. That would be an assault, and that would be a crime if two people were conspiring to do that. But this is, you're invoking the Ku Klux Klan law from 1871 for a reason here. Say a bit about that law and why you think that particular law applies here.
Yeah, so that law was passed by the Reconstruction Congress in 1871 specifically to deal with acts of kind of vigilante justice meted out by the Klan against racial minorities, which is precisely what happened in Charlottesville. The the purpose of the law was to give a private cause of action to people who were victims of conspiracy to commit racially motivated violence. Congress has the power to, Congress was essentially attempting to give teeth to the Reconstruction amendments, including the 13th Amendment, which prohibits slavery. And, you know, there was a motion to dismiss. It was decided by the judge that we had sufficiently pled a viable case under the Ku Klux Klan Act of 1871, precisely because this is exactly what we believe Congress had in mind when they passed the act 140 years ago.
Well, and that's fascinating too, and I'd like you to say a bit more about that because, and I read the judge's opinion. This is Judge Norman Moon in the federal court in Virginia, who decided, and just to be clear for the non-lawyers in our audience, it's not uncommon in any complex civil case to face a motion to dismiss, which is to say, is the pleading, is the complaint sufficient in its specificity, sufficient in stating the elements of a particular law that you're invoking to go forward, or should it be dismissed as a matter of law even before it has a chance to go forward? And that bridge has been crossed now with this case. The judge denied the defendant's motion to dismiss in large part in a fairly lengthy opinion, which we'll put a link to in the description for this episode. And I encourage people to read it because it has an awful lot of background about Charlottesville and about the case and the issues in the case. But you know, the 13th Amendment, which ended slavery, how is that relevant to a civil case against the perpetrators of racially motivated violence?
Right. So the Congress has the power under the 13th Amendment to address what is referred to as badges and incidents of slavery. And as the court found in this case, that includes, obviously it includes a right to be free from actual slavery, which is not what we're alleging here, but it includes also a right to be free from racially motivated violence, which is obviously what we are focused on here.
So, and again, is the evidence that you have that you believe supports invoking the Ku Klux Klan law and supports the allegations that this was racially motivated violence, and there were a lot of slurs and slogans that harkened back to the days of the Third Reich against Jews, and there were a lot of slogans used that invoked, you know, racial epithets and racially charged language against Black Americans. Is the evidence? I mean, how important is the evidence before the violence actually erupted, and how important is the evidence from the 2 days of the violence that actually occurred?
Yeah, it's all important, and I think it all tells the same story. I would encourage folks to read our complaint, which you can find at integrityfirstforamerica.org. But that lays out in very explicit detail exactly how obviously the plans to commit violence, but also that it was racially motivated. These defendants weren't shy by any means by talking about their interest, to say the least, to commit violence against Jewish people, Black people, LGBT folks, etc. And I don't want to detail all the evidence, but you can find it in the complaint. But for starters, I mean, kind of one headline for them was first stop Charlottesville, next stop Auschwitz. And there were very explicit invitations to their followers to come to Charlottesville so that you can commit violence against religious and racial minorities. So that's the evidence leading up to it. And then I think, as you mentioned, that the evidence from that weekend is, in terms of what they actually did, is entirely consistent. Mm-hmm. They committed violence against racial, religious minorities and their supporters, and then celebrated it after the fact as not just successful, generally speaking, but successful because of the violence that they committed. They celebrated having, quote, hospitalized dozens, and they celebrated the death of Heather Heyer as payback time for violence by communists previously. And so both before, during, and after, there's a very clear focus on violence and violence against these specific groups.
Tell us a little bit, Michael, about who the plaintiffs are in the case, and then I'll ask you about who some of the defendants are in the case, just so people have an idea of who's involved in this case.
Yeah. So the plaintiffs are residents of Virginia. That there are 8. They came out to peacefully protest, to peacefully send the message that hate has no place in the city of Charlottesville. They are students, law students, undergraduate students. There's clergy, doctors, etc. And they are folks that are concerned for their community, and they came out and with a very clear intent to send a peaceful message that white supremacy doesn't belong in Charlottesville.
And in order to be one of the 8 plaintiffs in this case, did they have to, or do they have to the that they not only were deeply disturbed by what was happening, but that they also were actually injured at the hands of the people who are being sued in the case?
Yes, absolutely. It's a requirement of civil litigation. So, and they all were. They were, and we have plaintiffs that were injured in kind of each different component of the weekend. So we have folks that were injured by the car attack itself. There are people who were assaulted both Friday night at the Thomas Jefferson statue and Saturday in acts of violence other than the car attack. So they all suffered significant injuries in some sense. And I will note, in addition to the physical injuries, the emotional and psychological impact that these events had, not only on our plaintiffs, but frankly on the city of Charlottesville generally, is substantial. And one of the most kind of striking components of this for me was when you go down to Charlottesville and you talk to people who were there, and who even people who weren't necessarily physically injured, there is a deep trauma in the community, just understandably by virtue of having been genuinely terrorized by a group of people that descended on the city and committed all these acts of terror and violence.
Well, and what about the defendants themselves? Because, I know, for example, in the aftermath of Charlottesville, there's been a lot of focus on the role of the police, the local police, and did they do a good job anticipating this and controlling the crowds in order to prevent or in order to reduce the risk of the kind of violence that happened from happening? I mean, obviously, a lot of people are very upset and critical of President Trump for the words that he's used and ways in which he is not speaking out forcefully enough against what happened there and in other situations. But there are the actual perpetrators of the violence. These are real people. They're individuals, and there are these groups. Tell us something about what you know about the groups that are involved here and that are the defendants in your case.
Yeah, so the defendants are basically, they are the lead organizers of the rally, and they unsurprisingly happen to be prominent figures in the white supremacy movement. They are some of them are local, although many of them local to Charlottesville, although many of them are not. We sued the individuals who organized the rally, but also the entities that they come from. So they are really kind of the who's who of the alt-right and white supremacy movement in America. And, they accomplished what they set out to do. And so, for them to sort of claim that the police are kind of responsible for not, I guess, thwarting their efforts to commit the violence that they carefully plan to commit, in our view, is, a little bit of a red herring, to say the least.
Mm-hmm.
But that's who they are. It's a group of kind of the more prominent white supremacists in this country.
Well, Michael, let me go back to the law that you're invoking as the basis for the civil suit. Some of the perpetrators have been prosecuted criminally.
Right.
The person who actually was behind the wheel that ran over all the people on the street and killed Heather High. I mean, he's been prosecuted, and I believe he got a life sentence for what his role. But this
Right.
is a civil case invoking, as you said earlier, this 1871 law. It's a little striking to me, given the history of racial violence in our country, that it's that we can even say today how extraordinary it is to invoke that law. I mean, we have a history of lynchings in our country over many decades. The Ku Klux Klan has been active, or certainly was active, in perpetrating acts of violence and murder many times over. Is there a precedent for invoking this 1871 Ku Klux Klan law? I mean, I know the law has been on the books, but is there precedent for that? And why do you think it is that it hasn't been used more in situations like what happened in Charlottesville?
Right. Yeah. So, I mean, there is some precedent for it. It was used, for example, to go after people who committed violence against the Freedom Riders in the 60s. It has been used. It was used in the 20s. It has been used sporadically throughout history for precisely this sort of action that we're focused on here in Charlottesville.
Mm-hmm.
I think that it is it's an important tool. It's an important tool to empower people like our plaintiffs to seek some sort of accountability using the courts where other tools haven't been used. And I think that it's not the only tool. It's obviously there's criminal prosecution and that has been used, excuse me, to some degree in this case too. As you mentioned, Mr. Fields has been prosecuted, and a number of the other attendees to the Unite the Right rally were also prosecuted. But it's there's an array of legal instruments to use to hold people accountable, and I think there's a sense, particularly amongst folks, I believe, in the Charlottesville community, that I think with good reason that there hasn't been as much attention and kind of legal emphasis on going after people that particularly organized the Friday night Torchlight March and some of the events on Saturday. And so I think to some degree this fills in a little bit of a gap to say that, we are going to hold you accountable.
Before I went to law school, the last project that I worked on as a journalist was an account of an SS officer who was brought to trial in Germany 40 years after he had escaped from a prison and had lived openly for 4 decades in Argentina. He was brought to stand trial. He was 80 years old when he was brought to stand trial in Germany. And one of the things that I explored in looking at that story and looking at the history is the role of a case, the role of a trial
Right.
in um, creating a record of what really happened, and the creating of that record in itself being a kind of accountability for not only the people involved directly, but uh, for our people, for our country, for
Right.
history, for the sake of history. Do you see in this case something similar?
Absolutely. I think that is one of the important aspects of bringing this suit, frankly, is that,
Mm-hmm.
I mean, I think particularly because there is confusion about, whether this really was just an expression of First Amendment rights. And I, I hope and believe strongly that when we have a trial, and there will be a trial in this case, um, that the evidence will come out and create, I believe, a very strong record that this was not about speech and this was not about spreading a message. This was about violent hatred. And I think, frankly, I'm not sure there there will be a better mechanism to kind of put that on display for everyone to see exactly what happened in Charlottesville and exactly, frankly, what I think a kind of primary goal of the white supremacy movement is. So
Mm-hmm.
I think it's very much a part of why this case is important.
Yeah, because you mentioned accountability and looking for, not only the people directly involved in bringing the case, but for the community as a whole. And I think you could argue
Right.
for the country as a whole.
Right.
The importance of accountability here, getting the facts out, understanding, as difficult as it is, understanding the facts of what actually happened and why it happened. Um, is that how you see accountability in a case like this?
I think it's multifaceted. I think that's
Mm-hmm.
one way. But I also think there is actually, um, because of this case, and particularly if we win, I think it provides a great disincentive to certainly the defendants involved, but also anybody who follows them or looks up to them or is considering kind of this sort of racially motivated violence. I think there is a genuine financial disincentive
Mm.
to um, to doing this stuff, and I think it already has had that effect to some degree in this case. With the some of the defendants have already been sanctioned for not participating in the litigation in discovery. But I also think that to the extent there's a finding of liability by a jury in the Western District of Virginia, as well as a judgment that follows, I think that provides a fairly significant financial disincentive, which, in addition to creating the record, is another powerful, powerful reason to bring the case.
Where are you in the case now? I know you mentioned that you expect that at some point there will be a trial, and I imagine before trial you have opportunity to take depositions, sworn statements from witnesses. Is that a process that you're engaged in at this point in the case?
Yeah, we're still in the middle of discovery,
Mm-hmm.
and it's been a long process. May not surprise you that the defendants who did what they did in Charlottesville also don't have a huge amount of respect for the legal system, and so um, trying to get their evidence, collect their cell phones, their social media accounts, etc., has been somewhat of a lengthy, litigious process. So
Mm-hmm.
we are very squarely in the discovery phase, and we are hopeful that there will be a trial at some point
Mm-hmm.
next
Do you
year.
have any idea when that might be? I know that that can be a fluid thing to try to pin down a trial date, but do you have any rough sense of when that could happen?
Yeah, it's I guess all I could say is that we're hopeful that it'll be sometime in the next year.
Mm-hmm.
but it depends a lot on sort of how the discovery process plays out.
Okay. And you mentioned earlier a nonprofit organization. What is that? Tell us a little bit about what that is.
Yeah, so Integrity First for America is a nonprofit that does a number of different things focused on, among other things, combating hate. And so we've been fortunate that they've supported us in bringing this case and shedding some light on it.
Mm-hmm. If people want, yeah, I'm sorry. Go ahead, Michael. I didn't mean to cut you.
No, I was just going to say the website is integrityfirstforamerica.org,
Mm-hmm.
which talks about what they do as an organization and also includes the legal filings in our case.
Oh, good. Okay, so if people want to get, you mentioned the complaint and also the opinion that you had sent me so I could read up on this beforehand. Those are materials that people can access at that website?
Yep, absolutely.
Okay, good. Maybe let me finish with this and see what you think and what thoughts you have on this. Obviously, as we said at the outset, Charlottesville has a special, really extraordinary place in the history of racial violence in our country. It is still being talked about. We're entering a political season as people start to gear up for the 2020 races. It's going to be talked about more, I believe, too.
Right.
But obviously, in some sense, Charlottesville is not unique either. I mean, these organizations, these white supremacist groups, white nationalist groups, they have engaged in acts of violence in other parts of the country. What do you think are the broader implications for your case? How do you think this may be meaningful beyond getting a sense of accountability out of the events that happened in Charlottesville itself?
Yeah. Well, I think so. In a lot of ways, Charlottesville was kind of a catalyst for some of the violence that followed. There's clearly a kind of there's a new boldness on the part of white nationalists and white supremacists to get out there and to be bombastic and to even be violent. And I think the other thing that's evident from this the events in Charlottesville, but also which I hope will become more evident in our litigation, is the role of social media in providing a platform and an outlet for white supremacists and white nationalists to get their message out and attract followers and plan more incidents like this. So I think, at the very least, for folks to have a greater understanding that white supremacists are focused, they are bold, they are using the internet, they are spreading their message, they are collecting followers, and I think the role of social media platforms in enabling that in some sense, perhaps passively, will be hopefully important to shed some light on various areas that policymakers and law enforcement can focus on to try to tamp down on this.
Okay. Well, Michael, tell us how people can reach you. You told us about the website already, but how can people reach you if they want to get more information or if they have information that might be useful to the case, things like that?
Yeah, so I'm at Kaplan, Hecker, and Fink in New York. We have a website. I'm on the website, so people can find me there. I am also on Twitter at Michael Bloch 15.
And Bloch is B-L-O-C-H?
Yeah, correct.
Okay, good. All right, and we'll put a link to that as well in the description for this episode. Michael Bloch, thank you so much for speaking with me today and talking about of what happened in Charlottesville, about the case that you're involved in, and some of the broader implications of what happened and what some people are actually doing about it. Fascinating case invoking the Ku Klux Klan Act from 1871. Good luck with everything. And again, thanks so much for being on Good Law, Bad Law. Appreciate it.
Thanks so much, Aaron. Really appreciate it.